My name is Severina McGill and I teach at Jindal Global Law School. This module is for the E-Pathshala UGC. This module is on conflict, violence and women's human rights in India. The content writer is Saeed Alia Anjum. The aim of this module is to understand how and why conflict has affected women's human rights in India, primarily due to enforced disappearances and sexual violence, and to identify the main human rights that are violated as a consequence. It also helps in understanding the applicable international human rights law framework. Finally, it helps to identify and analyse the redressal mechanisms available and their effectiveness in providing gender-sensitive justice. The UN Special Rapporteur on Violence Against Women, Its Causes and Consequences has, in 2014, said, "Women living in militarised regions such as Jammu and Kashmir and the northeastern states of India live in a constant state of siege and surveillance, whether in their homes or in public." Information received through both written and oral testimonies highlighted the use of mass rape, allegedly by members of the state security forces, as well as acts of enforced disappearance, killings, and acts of torture and ill treatment, which were used to intimidate and to counteract political opposition and insurgency. Testimonies also highlight the impact of the situation on women's health, including psychological disorders such as post-traumatic stress disorder, fear, psychosis, and severe anxiety, with such conditions having a negative impact on women's physical well-being. Additionally, freedom of movement, freedom of association, and peaceful assembly are frequently restricted. The specific legal framework that governs these areas of law, namely the Armed Forces Special Powers Act and its variations, allow for the overriding of due process of rights and nurtures a climate of impunity and a culture of both fear and resistance by citizens. In India, special security laws like the Armed Forces Special Powers Act, herein AFSPA, have been enforced for prolonged periods of time in several regions, most notably in the northeastern states of India and in Jammu and Kashmir. In Assam and Manipur, AFSPA was enacted in 1958 and 1990 saw the introduction of the law in Jammu and Kashmir, with the outbreak of armed insurgencies challenging the Indian state's sovereignty in these states. This module will focus on how the use of AFSPA and other immunity laws have affected women and children's human rights in these regions. The vaguely formulated provisions of the AFSPA grant extraordinary powers to the Indian armed forces in these areas, including powers of shooting to kill and arrest on suspicion, whilst also providing troops immunity from prosecution for acting in pursuance of these powers. According to human rights organisations, these laws have facilitated wide-ranging human rights abuses including torture, arbitrary detentions, extrajudicial killings, enforced disappearances and sexual violence. These have all been perpetrated without accountability. The Indian government appointed committees, human rights organisations and the UN all have called for the repeal of AFSPA. For instance, in 2005, the government appointed Justice B.P. Jivan Reddy Committee recommended the repeal of AFSPA, which is yet to be acted upon by the central government. New disappearances stopped after the Manipur government introduced a system for providing arrest memos. Women have been raped and murdered, children killed in crossfire, and boys as young as 14 have been detained and tortured by armed forces for suspicion of being militants. In Jammu and Kashmir, the situation is no different. Apart from AFSPA, special security laws like the Public Safety Act from 1978 continue to be enforced and feature provisions granting immunity from prosecution to troops for acts perpetrated under these laws resulting in human rights abuse. While all of these abuses have a gendered impact, the two violations that most disproportionately affect women are enforced disappearances and conflict-related sexual violence. According to the Association of Parents of Disappeared Persons, or APDP, 10,000 persons have been subjected to enforced disappearances since 1989 in Kashmir. By conservative estimates, this has resulted in the presence of over 1,500 women, also known as half-widows, whose husbands are disappeared but have not been declared as dead. Also, The International People's Tribunal on Human Rights and Justice in Kashmir, the IPTK, established the presence of 2,943 bodies within 2,700 mass unmarked graves, some with multiple cadavers, in 3 districts of North Kashmir in 2009. 2 more districts have been investigated by the IPTK since, taking the number to over 6,000 unmarked graves which hold the bodies of unknown people. Some, including the State Human Rights Commission, believed they might contain several of the disappeared persons. In Manipur, the incidence of disappearances has reportedly reduced in numbers since the mid-2000s. However, they continue to happen unabated. Whilst hard documentation on the number of survivors of sexual violence is absent, mostly due to the obvious impediments and stigma attached to reporting such crimes, and a lack of specialised services, avenues for redress, and the fear of reprisals, human rights and media organisations have often highlighted its high incidence in Kashmir. One quantitative study conducted by Médecins Sans Frontières in 2005 noted the unusually high occurrence of sexual violence in Kashmir since 1989, with 11.6% of respondents saying they themselves were victims of sexual violence. 2/3 had heard about rape, and 1 in 7 had witnessed a rape over the same time period. Similarly, rape and sexual assault by security forces have routinely been reported in the northeast region of India. For instance, in Assam's Kodrathar district, a deaf and dumb woman was raped by the paramilitary in 2011 in front of her husband. The National Human Rights Commission went on to state, because no appropriate action was taken so far to punish the culprits involved in previous incidences, the crimes have been repeated again and again in the district. The famous murder and rape case of Tanja Marorama from Manipur remains unredressed to date. The next section will deal with international human rights law frameworks. The first part talks about enforced disappearances. The International Convention for the Protection of All Persons from Enforced Disappearances in 2006 imposes specific obligations on state parties to prevent, investigate and punish cases of enforced disappearance. India signed the convention on the 6th of February 2007, though it has not yet ratified it. As a signatory, India has under an obligation not to act contrary to the object and purpose of the treaty. As per the Vienna Convention on the Law of Treaties from 1969, the Convention has laid down 3 constitutive elements of enforced disappearances under Article 2. These include arrest, detention, abduction, or any other form of deprivation of liberty, by agents of the state or by persons or groups of persons acting with the authorization, support, or acquiescence of the state, the refusal to acknowledge the deprivation of liberty, or by concealment of the fate of the whereabouts of the disappeared person, which places such a person outside the protection of law. The Working Group on Enforced or Involuntary Disappearances, in its general comment, has articulated that enforced disappearances are a continuous offence, so long as the perpetrators continue to conceal the fate and whereabouts of the person who has disappeared. This is because the disappeared person is continuously deprived of access to rights as long as he or she remains dispossessed of their liberty. Pertinently, any person who has suffered harm as the direct result of an enforced disappearance is also considered a victim within the meaning of the Convention. Therefore, the female next of kin of the disappeared person is also a victim of this continuous violation, and she is entitled to protection under the Convention. Additionally, enforced disappearance violates a range of rights contained within the International Covenant on Civil and Political Rights from 1966. India ratified this treaty in 1979. The Human Rights Committee, the body responsible for monitoring state compliance with the ICCPR, has acknowledged that disappearance and lack of contact with the outside world constitutes cruel and inhumane treatment, and therefore is a violation of Article 7 for both the victim and the victim's family. In other cases, the committee also held that prolonged incommunicado detention in an unknown location amounts to torture, cruel and inhumane treatment. Regional courts like the European Court of Human Rights have also concluded that a mother's severe mental distress caused due to complacency of authorities regarding disappearance of her son also amounts to inhumane and degrading treatment. The next part of this module will deal with conflict-related sexual violence against women. This has been the subject of many international and regional treaties and universal UN Security Council and General Assembly resolutions. One of the key instruments are the 4 Geneva Conventions of 1949, which India is party to. They provide specific guarantees against rape and other forms of sexual violence against women in an armed conflict. For instance, Geneva Convention 4 provides that states are obliged to protect women against any attack on their honour, particularly against rape, enforced prostitution, or any other form of indecent assault. The Committee for the Elimination of All Forms of Discrimination Against Women, which monitors implementation of the treaty, also has mentioned violence against women, particularly within conflict. The treaty came into force in 1981 and India became a state party in 1993. The Committee, in General Recommendation 19, has stated that gender-based violence hampers the ability of women to enjoy rights on par with men. Hence, any kind of violence against women, including sexual violence perpetrated by public authorities, amounts to discrimination against women and violates CEDAW's provisions of non-discrimination. This reasoning can also be applied to non-discrimination provisions of the ICCPR and the ICSCR, the International Covenant on Economic, Social and Cultural Rights, both of which India has been a party to since 1979. The jurisprudence of the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda have also provided general guidance on the international legal principles on sexual violence by interpreting rape in armed conflict as an act of torture, a crime against humanity, and even genocide. This is when it is committed in certain circumstances. The Rome Statute of the International Criminal Court from 1999 strengthened these conclusions by making rape and other forms of sexual violence punishable as a war crime and a crime against humanity when committed as part of a widespread or systematic attack directed at a civilian population. Hence, international law places rape and sexual violence in armed conflict in the category of the most serious crimes when committed in a certain set of circumstances. Further, a range of UN resolutions specifically concern sexual violence in conflict and direct states to prevent and prosecute these abuses. Key resolutions include the United Nations Security Council resolutions. The UN Security Council Resolution 1960 from 2010 asks state parties to take time-bound commitments to combat sexual violence in armed conflict, including clear orders through chains of command to the effect instructions in military manuals and in codes of conduct. Resolution 1888 from 2009, among other things, also urges states to ensure access to justice for cases of sexual violence and that survivors are treated with dignity in the redressal process. Resolution 1820 from 2008 demands the adoption of disciplinary, training and vetting measures in the military to prevent sexual violence, apart from stressing the need for ensuring accountability and prosecution of personnel engaged in such crimes. Resolution 1325 from 2000 on Women, Peace and Security asks state parties to adopt special measures to protect women from rape and sexual violence in armed conflict, among other obligations. In 2008, the UN General Assembly issued Resolution 62134. The purpose of this was to eliminate rape and other forms of sexual violence in all of their manifestations, including in conflict and conflict-related situations. The resolution urges states to adopt measures to prevent sexual violence in armed conflict, to end impunity for it, and to provide counselling and health services to survivors, among other things. UN General Resolution 3318 from 1974 also declares the protection of women and children in emergencies and armed conflicts. The declaration makes a plea towards states to comply with their general obligations under international instruments and under the Geneva Conventions for the protection of women and children in armed conflict. There is no reference to special vulnerability of women to sexual violence during armed conflict in this document. The following section focuses on the gendered impact of conflict. This part emphasises enforced disappearances from a women's rights paradigm. Whilst it is acknowledged that the majority of the disappeared in Manipur and Kashmir are men, it is a foregone conclusion that the women relatives of disappeared persons share this abuse. Not surprisingly, the Convention Against Enforced Disappearances also considers those who have suffered harm as a direct result of the disappearances as victims. Female relatives of the disappeared suffer a range of legal and social challenges, apart from difficulties of looking for the disappeared person. For instance, half-widows are deprived of their basic social and legal safety nets after the disappearance of their husbands. Whilst widows are entitled to a pension under a government-run social welfare scheme, half-widows cannot claim the same claimants because they must produce a death certificate to be eligible. They, and other kin, can also not access the government's ex gratia relief without a death certificate and proof that the deceased had no link with militancy. Further, under state law, half-widows have to wait 7 years from the date that they file a missing persons report and FIR before their husbands are legally declared as deceased. This prevents them from being able to remarry or inherit their husband's property or claim their widow pension due to their lack of recognition and status as a widow. The fact that nearly all half-widows are from lower-income families and were entirely dependent on their husbands economically makes their situation even more precarious. With the breadwinners of the family gone, half-widows or other female kin of the disappeared are forced to step into the public sphere, often for the first time, which they may not be equipped to face due to the lack of education or other skills required to earn for the family. In Kashmir, in many cases, half-widows are deserted by their in-laws, who often also keep their children. This makes them dependent on their maternal families, which is culturally disapproved of. The imposed status of single women further forces social biases and vulnerability onto them in a patriarchal society. Many women also have significant health-related consequences. Many female relatives of the disappeared have been reported to suffer from trauma or depression. One study revealed that half-widows in Kashmir comprised of 30% of the suicides in the first 20 years of the conflict. The UN Special Rapporteur on Violence Against Women, Its Causes and Consequences, has highlighted the impact of living in a conflict-affected society on women's health, including psychological disorders such as post-traumatic stress disorder, fear, psychosis, and severe anxiety. Such conditions have a significant negative impact on women's physical and psychological well-being. These hardships deprive women of the right to lead a dignified life under Article 6 of the ICCPR, the right to compensation, the right to family life, and the right to lead a life free from discrimination. They are also deprived of their rights owing to their gender. Notably, an enforced disappearance amounts to an arbitrary interference in the family and home of the relatives within the meaning of Article 17 of the ICCPR. Since the deprivation of liberty is done in a manner that contravenes the aims and objectives of the Covenant. This part focuses on the sexual violence and its human rights implications. Since the early years of the conflict, sexual violence has regularly been reported in Kashmir and the northeast, often implicating the Indian Armed Forces. The lack of accountability for such violence has also been regularly highlighted in the media and by human rights organizations. Although some incidences of rape by non-state actors have also been reported, such instances are few and far between compared to those allegedly perpetrated by state forces and which do not invite international legal obligations as state actors do. The Kannan Poshpura rape is one of the oldest and most well-known incidents of rape in Kashmir. More than 30 women and girls from the local twin villages of Kannan and Poshpura were reportedly raped by armed forces in the same night during a search operation in February 1991. The eldest survivor was reported to have been 80 years old at the time of the incident. Some estimates place the number of rapes as high as 100. 7 years after the institution of the case in 2004, at the Jammu and Kashmir State Human Rights Commission, It finally acknowledged in its 2011 order that the then director of the prosecution had severely botched investigations to exonerate the involved armed forces. It subsequently ordered his prosecution. Although it did not order compensation to the victims, it was silent on the guilt and prosecution of the soldiers involved. The compensation also remains unpaid. More recently, on the 30th of May 2009, the body of the sister-in-law duo of Asiya, who was 22, and Nilufer, who was 17, were found in a shallow stream in an area flanked by police, paramilitary, and special operations groups, a unit comprised of renegade militants. Encampments in Shopian, Kashmir. A post-mortem ordered in the wake of mounting public outrage confirmed rape. A judicial commission, instead of criminal investigation ordered by the Chief Minister, also confirmed rape and murder. However, the Central Bureau of Investigation, to which the case was later handed for investigation, ruled out rape and attributed the deaths to drowning. This is a conclusion that was refuted by a parallel investigation carried out by the Jammu and Kashmir High Court Bar Association and the Indian civil society groups. Other well-known examples of rape include the cases of Chandpura Pazipura from 1990, Chak Saidpura from 92, Tenho Budhapari Kangan from 94, Vavusa in Srinagar in 1997, and the rape of a woman and her 10-year-old daughter in Handwara from 2004, among others. Additionally, women were also reportedly raped, sexually humiliated or molested for kinship ties or sympathies to suspected militants. A recent study from the Centre for Policy Analysis report on the Kannan Poshbara rape case highlights the general and long-term social and psychological implications of sexual violence for women in Kashmir. Women from the villages have faced strained relations in their marital homes and ostracization from a deeply patriarchal society, which often considers women's bodies a matter of familial honor, and where loss of virginity and consensual or forced sex outside of marriage is stigmatized. Expectedly, unmarried women from these villages who have experienced sexual violence or are presumed to have experienced it face trouble finding a suitable husband. The Centre for Policy Analysis report also states that the women suffer from trauma and require medical attention. The report adds that many women also suffer from physical ailments, and a dozen have had to undergo hysterectomies as a consequence of the violence. In Manipur, there have also been multiple reports of rape. In his speech objecting to and calling for an end to AFSPA, Mr. Lashram Achau Singh, an MP from Inner Manipur parliamentary constituency, himself referred to an incident where the widow of a tribal official was raped within her home after military personnel trespassed onto her property. The 2005 Government of India report on the Committee to Review the Armed Forces Special Powers Act also documented several instances of rape and sexual violence. The report urged that such attacks violated the very dignity of people the forces are supposed to protect, and thus called for the Act's repeal. Sexual violence was also reportedly committed by vigilante groups and police in the Naxalite conflict, whilst paramilitaries in the state of Manipur were accused of raping women. As mentioned before, the case of Tangjam Manorama gained a lot of popular and media attention, also because of the protests that followed it. On the 11th of July 2004, the then 32-year-old Manorama was abducted from her home by paramilitary forces, widely agreed to be from the 17th Assam Rifles Regiment. Manorama was forcibly taken from her home in the early hours of the night on suspicion of being a militant. She was found dead the next morning with marks on her genitals that suggested that she had suffered severe sexual violence before being killed. On Manorama's body, there were scratch marks and deep gashes on her right thigh, probably made by a knife. There wasn't a single bullet wound on Manorama's legs, but there were 16 bullet wounds to her genitals. It is widely believed that the large number of bullets that were fired at her genital area were deliberately targeted with the intention of destroying any evidence of sexual violence. On the 15th of July, around 30 women from Manipur held a naked protest outside the army barracks against what they perceived to be the ability of the army to rape and murder women with impunity, under the Special Powers Laws. These women were demanding an inquiry and repeal of AFSPA. The official inquiry was conducted in 2004, but it was not released for 10 years before being handed over to the Supreme Court in 2014. The inquiry revealed the brutal and merciless torture and killing of Manorama by the 17th Assam Rifles Regiment. In December 2014, the Supreme Court ordered the government to pay rupees 10 lakhs as interim compensation to Manorama's surviving mother, although no prosecutions have taken place. These cases and their effects fully demonstrate that sexual violence against women is incompatible with the dignity of a human person and needs to be eliminated and accounted for as a violation of women's fundamental human rights. As mentioned earlier, rape is a form of gender-based discrimination and denies a range of human rights to women. These include the right to life, the right to liberty and security of person, the right to equality in the family, the right to the highest attainable standards of physical and mental health, and the right to not be discriminated against on the basis of sex. It has also been observed that rape satisfies the Convention Against Torture's definition of torture when used to obtain information or a confession or, for any reason, based on discrimination or to punish, coerce or intimidate, and is performed by state agents or with their acquiescence in those instances. It then constitutes a violation of the right against torture, inhumane and degrading treatment. The following section deals with available redressal mechanisms and their effectiveness. The first topic deals with barriers in accessing justice. The Indian Constitution guarantees the right to constitutional remedies to its citizens as a fundamental right. However, the redressal mechanisms for victims of enforced disappearance and sexual violence fail to remedy those violations effectively, as the following paragraphs will demonstrate. First information reports, the first available remedy to the kin of a disappeared person, is filing a missing persons report, or a first information report, with the concerned police station as per the requirements of the Code of Criminal Procedure. In many cases, the police refuse to file FIRs, especially those that implicate the armed forces. This policy was institutionalized in 1992 when the Jammu and Kashmir Home Department passed a circular directing the police to refuse refiling FIRs against armed forces without permission from a higher authority, and to refrain from recording accusations of their misconduct in the daily logs. Habeas corpus petitions are also available, and relatives can file these petitions, usually in the State High Court under Section 491 of the CRPC. This provides for filing petitions against extrajudicial detentions. A Yale Law School report detailed the fate. Usually, the state denies knowledge of the detainee. Court orders and judicial inquiries on formal requests of the petitioner are also available. On receiving inquiry findings, the High Court can either direct the police to file an FIR against the armed forces or, if it is found involved, order the government to pay compensation to the victim's family, if they cannot produce a detainee. However, victims have received compensation in only a few cases, and FIRs were filed in even fewer. Further, there is a pendency of thousands of habeas corpus petitions in Kashmir. Many favourable orders are not complied with by the authorities, and the court takes no action against those in contempt of its orders. The State Human Rights Commission and public interest litigation are also options. The state response to sexual violence implicating the armed forces has ranged from denial to lack of meaningful redress. The Kannan Pushpura rapes were dismissed by a single-member investigation of the Press Council of India, which exonerated security forces whilst questioning the women's integrity. The State Human Rights Commission had recommended compensation to be paid to the survivors in 2011. The same was ordered by the Jammu and Kashmir Court in a public interest litigation instituted by a local human rights group for the implementation of the Human Rights Commission's recommendations. Notably, the High Court had also ordered a special investigation team to conclude investigations into the case with reasonable dispatch. However, The Supreme Court has recently stayed the case proceedings. In the Shopian case, the CBI's upholding of the death by drowning theory and the ruling out of rape by its team of doctors and state-sponsored SITs has effectively foreclosed any hope of a legal remedy in this case. Nonetheless, the circumstantial evidence and the parallel civil society investigations coming to an opposite conclusion put an official question mark on the official version of the facts. Court-martials and sanctions are also available. Soldiers accused of rights violations, including rape, have the option of being tried in a court-martial rather than in criminal courts. In almost all cases where the question of trial arises, the armed forces choose court-martials which lack transparency. For example, in the Handwara case, after public anger, the army instituted court-martial proceedings and acquitted the accused major of rape charges, although it ordered his dismissal from service on less serious grounds. There are hardly any cases of court-martial sentencing beyond dismissal or suspension. Further, for sanctions sought for prosecutions under AFSPA, the result has been complete impunity. No sanctions were granted in any of the cases where they were sought by the state government. The 4 A's of accessibility of justice. Apart from these institutional barriers, there are other obstacles in accessing justice, which, as a number of scholars have pointed out, need consideration. Due attention has to be paid to these broader structural, economic and social factors in understanding accessibility of justice. For example, to holistically understand justice, we should consider geographical accessibility. A considerable number of cases mentioned above are located outside of the state capital, where most of the administrative headquarters, Court of Appeal and State Human Rights Commission are located. This distance makes it almost impossible for the survivors or their families to access and seek justice. Financial accessibility. Almost all cases of human rights violations concern lower income families who find it financially challenging to pursue justice in courts. The financial implications of travelling long distances are also not relieved. The prospect of a heavy financial burden deters survivors from taking a decision to initiate or pursue judicial proceedings. Cultural accessibility may also be a barrier. Reporting sexual violence is especially challenging considering the stigma it carries in a deeply patriarchal society like South Asia. Even a decision to institute a legal process in courts is socially significant, given that it is usually considered a long-drawn and expensive procedure, hence representing an obstacle in accessing justice. Information accessibility. Usually, victims lack education on the legal avenues and options of legal aid available to them. Also, there are no serious efforts by the government to enhance human rights education and awareness of rights in the region. This lack of information acts as a serious impediment for survivors to seek justice in the first place. The United Nations Development Programme (UNDP), in its report on strengthening judicial integrity through enhanced access to justice, stated that access to justice involves normative legal protection, legal awareness, legal aid and counsel, adjudication, enforcement and civil society oversight. In the context of Kashmiri women, these requirements are seriously lacking, as the preceding discussion made clear. Institutional impediments make the situation even grimmer. The following paragraphs entail the conclusion. The Jammu and Kashmir Government State Human Rights Commission confirmed the presence of 2,156 unidentified bodies in mass graves across Kashmir and ordered compensation to the victims. Despite this, no serious effort in identifying the bodies and in paying the compensation to the families has been made. Whether in Kashmir or in the northeast, there has also not been any recognition of the economic and legal hardships faced by the female next of kin of disappeared persons. For instance, the requirement of death certificates for granting ex gratia relief of pensions to the half-widows has not been waived, nor has the woefully long waiting period of 7 years in declaring a disappeared person to be dead been reduced. This leaves women of the affected families in a legal limbo that negatively affects their lives and that of their children. Similarly, in cases of conflict-related sexual violence, the state's attitude has been of denial and impunity. The failure of recognising sexual violence by public authorities ignores the fact that all forms of violence against women seriously violate and impair or nullify the enjoyment by women of all human rights and fundamental freedoms, and constitute a major impediment to the ability of women to make use of their capabilities. It also deprives the affected women or families of closure, redressal, and reparations, which are their rights. The state has acted in a gender-blind fashion in not paying any attention to the psychosocial counselling, financial assistance, or providing skills to the affected families. These efforts, which are required of the state under its obligations to respect, protect, and fulfil human rights, are therefore seriously lacking.